Hello, and thank you for tuning in to the TIE Demon Beta podcast, where we'll be trying to address various topics within the original trifecta of science, technology, and gaming with me, Curtis Miller, as your host. Today is the 25th of March, 2015, and we're talking about stored communications data within the 2014 Data Retention Bill. Now, the Australian Parliament this year looks like they're finally going to catch up with technology. The laws that are currently in place were put in place around the time of the Cold War, and a bit before, and so they're really not up to scratch. They had no idea back then that people would be using the internet in the way they are now, doing things like sending pictures of various appendages across the world to people you only met 15 minutes ago. And they'll be starting updating these laws with the laws regarding what information your telephone company and your internet provider are recording on you. In the last podcast, I did mention that the data that is being recorded on you is split into two separate groups. The first group is the telecommunications data, which pretty much lists everything about you as a person and what you've been using that service for, be it a Facebook service, or the service that you get for using your phone, or the email service that your ISP provides, or any other service that is used on the internet or with a phone. And then there's the stored communications. That's all of the actual information that was sent using that service, be it a tweet, a Facebook post, or an email or a phone call. Now, I'm going to make a disclaimer here and say that the law does not specifically relate to any of these services. It's defined in what is called technologically neutral terms. This is so that as technology changes, or any unforeseen forms of technology are all included by the law will apply in an obvious manner to all of them, because it uses terms like content and substance and data, so it's fairly obvious how this applies to each situation, and it's not specific to any of them. So, what exactly is stored communications data anyway? Well, it's a lot of things, including all of the telecommunications data. So all of that information about who you are, what you did with Facebook, when you did it, where you were when you did it, and who you did it to. All of that is stored communications data as well. But stored communications data goes even further. It includes what you did. I mean, the whole of what you did and everything included. By this I mean, if you sent a picture and put a picture up on Facebook, it includes that picture. If you sent a mean text to someone, it includes that mean text. If you sent a 5-page email to some politician explaining why you think it's a bad idea to introduce laws that record data that's recorded on you, it includes that entire email. I'll go into a few more specific examples to outline this. Say your grandma, who's been using the email address provided to her by Big Pond, sends you an email to your good old Gmail account, which is wonderfully secure. It's offshore, it's hosted in another country, you're all set, you're all good. What in this case is stored communications data? Well, let's start off with the telecommunications data, which is who it was sent between, when it was sent, the size of the file, and stuff like that. And then the stored communication stuff includes what was written in the email itself, all the attachments for the email, so that picture of her new pet dog that she sent you, that's all in there, and that's all accessible as stored communications. But who's holding on to it? Well, in this case, both Big Pond and Gmail are holding on to all of the information about who it was sent between, when it was sent, how big it was, as well as the email itself. This can be avoided, however, if you just delete the email. If your grandma deletes the email after she sends it, Big Pond probably doesn't hold on to it. And if you delete the email after you've done reading it, Google will maybe delete it a while later. It's kind of vague. They tend to hold on to stuff anyway. So all of that stuff that's being held on to, that'll be accessed as stored communications if you ever get into any trouble. Let's look at Skype. Everyone uses Skype now, I think, or FaceTime or whatever. Skype is interesting because I know a few odd details about it, including the fact that the service provider, in this case Microsoft, doesn't hold a lot of information about what goes on in Skype because of the way it works. Instead of all of the information going to Microsoft and then being handed off to whoever you're sending it to, so if you have a video call, the video doesn't go through Microsoft to get to where it's going, or even if you send a chat message, it doesn't get sent to Microsoft who sends it to the other person. Microsoft just tells your computer where to send it, and it goes straight there. So Microsoft in this case records very little. What they do record as telecommunications data is the stuff like your name, your account details, your phone number if you've given it to them, your email address, when you were communicating, when you sent certain messages, when you made a call, how long you call for, all of that incredibly detailed stuff, but they don't record any video, they don't record any audio, they don't even record the messages themselves. So what could potentially be considered communications content isn't actually recorded here. It's pretty much only the telecommunications data. So Skype is pretty safe, unless the person you're talking to is someone you shouldn't be talking to. Let's go old school now and talk about phones for the 5 people who still use them out there. Say there's a phone call made between your good old grandmother's house from her landline phone that she's had for 20 years and your newfangled iPhone. What's recorded then? Well, in her case, Telstra is going to record all of her account details, when the call started, which phone number the call was made to, where her phone is, where the telephone lines are, and everything about her end that they know, plus the phone number that it was being sent to. And then there's your end, say you're with Vodafone. Vodafone would record your number, all of your contact details, where your mobile phone was when the call was answered, and how long the call went for, and who called you, of course. But they wouldn't know much about the other end. So your service provider contains a lot of information about you, but not much about who it was coming from or who it was being sent to on the other end. And in this case, phone companies don't really record phone conversations, so it can't be accessed as telecommunications data. The text messages, however, can. The text messages get stored with your telephone provider and then get sent back out to the phone when it comes online. Now, some providers will delete the message after this and won't hold on to them for very long. Others may hold on to them indefinitely. It's not very clear as to which do what. So all of those text messages and any voicemail that gets left because you didn't pick up your phone, that's all stored communications data until it gets deleted. Basically, to sum it all up, stored communications data is a lot. It's pretty much any information that is possible to record on you over the internet, but it only counts if it's held onto. If it gets deleted after a time, then it can't be accessed as stored communications data, and there's no requirement for any of that to be held onto. The only requirements for stuff to be held onto is the telecommunications data, which in itself is still very intrusive. All of that stuff on your Facebook wall that doesn't get deleted, that can all be accessed. All of your tweets can be accessed. All of those nasty messages you send through Facebook can be accessed. And then there's cloud services. Anything you store on Google Drive or Dropbox or Box or OneDrive or iCloud, all of that is stored communications data and can be accessed as such. So if you've got some suspicious documents on there, they'll get found. Any messages that you send through things like Hangouts or iMessage or Snapchat or Kik, all of that stuff, if it gets held onto, that's stored communications data. And scarily, you may not know this, but Google keeps track of what you search. They have a very extensive history of everything you've ever searched for, unless you've been private browsing or you've deleted it all. That's stored communications data too, and a lot can be learned from that. Just about any information that goes over the internet can be considered stored communications data if it gets recorded somewhere. So, there's a scary amount of information that's covered by this. So, who has access to it? Does MI6 over in England have access to it? Does the NSA have access to it? Well, kind of, but not explicitly. The government's probably not going to say much on that. But within Australia, currently, there's a number of shire and city councils that have access to it, as well as non-government agencies like the RSPCA. If the bill comes in, that will change. It'll get dramatically reduced from more than 80 agencies down to 14. 14 agencies that have to be explicitly listed in the legislation. So you can look up the law and you can say, these people can access my information. And I'm afraid to say it, they're all pretty much acronyms. There's the AFP, the ACCC, the Law Enforcement Integrity, the State Police Forces, the ASIC, the ACCC, the Crimes Commission, the ICAC, the Police Integrity Commission, the IBAC, the Crime and Corruption Commission of Queensland, Corruption and Crime Commission, and other such agencies. But there's 14 in total, and if one agency needs to get permanent access to all of that data, they have to have the law changed to include them in that list. There are other ways for other agencies to get access to that data. The Attorney General can at any point, under certain circumstances, say that Agency X, say the RSPCA, really needed to look at some stored communications data. The Attorney General could say, for 40 sitting days of Parliament, which is roughly 8 weeks, you have access to that data, but he can't say any longer. It has to be 40 sitting days. And after that period, that agency no longer has any access whatsoever. And as I said, the only way to give them permanent access is to have a bill introduced in Parliament that permanently adds them to the list. And that bill has to be reviewed by the Parliamentary Joint Committee on Intelligence and Security, and they have to have at least 15 days to review it. And then that law may be reviewed. So it's not exactly easy getting a name added to the list. Thankfully, if this law passes, dramatically fewer people have access to this information. Still, couldn't say a basic police force have randomly get access for, say, me pirating a film? And the answer is not under this law. See, access to stored communications is classified as interception of telecommunications. And to intercept telecommunications, you need a warrant, which, yes, is just a piece of paper which is given to you by a judge, and sadly, still has to be applied for in writing, which means someone has to write a letter and mail it off. They may accept fax, but this is the Australian government we're talking about. They're not exactly up to date. And of course, if the situation is particularly urgent and you're a high-up chief officer, then you can call it in. When this warrant is granted, a judge has to kind of mull over what's been given to them in this piece of paper and say, well, is it likely to help? How much is it going to help? Have they exhausted all their other methods? Isn't there something else they could do? Is this the only way they can get the information they need? Is this really worth giving access data to? I mean, are they just investigating some guy who broke into a shop, or is this guy leading some sort of drug smuggling ring? And if all of those checks pass in some sort of vague manner, then the warrant gets handed out. This system is the same system as is currently in place, and it has been described as outdated and complicated, and it kind of still is. And there's another caveat to how your data is accessed. You don't actually have to know that it's happened. In fact, in certain circumstances, you're not allowed to know that your data has been accessed. So that's a bit of a bummer. Still, these agencies have to go through some really obtuse means of getting access to your data. But hey, bright side, there is fewer of them. Let's look on the good side, there's fewer agencies. And you know, this will help them in catching criminals, surely. I mean, surely this can't be simply avoided by downloading a piece of software from a basic Google search. And, well, actually, it kind of can. You can access this software called the Onion Router, which will anonymize all of your traffic, so any website you go to will have no idea where you are or where your data has come from, unless you log into that site and just tell it who you are and where you come from. And that's a very effective way of hiding yourself online. And then there's also VPNs, or virtual private networks, and that just means all of your information goes through another computer on the internet before getting to where it's going to. So say you're looking at some suspicious website, or you're looking at some pretty questionable stuff online. If you use a VPN to get there, that website won't know who you are or where you've come from. Though if you just use the same VPN to access every website and hide yourself from those websites, then the government only actually has to look at that VPN to see where you've been, because the owner of the VPN is still a service provider, and they'd have a very extensive record of where you're looking. So I wouldn't really recommend using VPNs if what you're going to do is try and get around this law. It's a pretty dumb way of trying. And then, of course, there's the ever-complicated means of getting around this law simply by, or at least restricting the data that's recorded that can be provided under this law by going to the settings of your browser and turning on private browsing. Yeah, that actually makes a big difference. That thing I mentioned about Google earlier, tracking every website you go to and everything you search for in Google, well, that list becomes lots of very small lists that are very hard to attach to you. So it's pretty much gone, and any website you don't log into doesn't really track much about you if you turn that on, except maybe your IP. So it becomes a lot harder to try and figure out what sites you've gone to and when you went there and if you went there. So private browsing, very simple solution to greatly reduce the amount of information that's being recorded on you. It seems that these laws aren't as up-to-date as they could be. So on that bombshell, where we find out that these laws really don't help the goal that the Australian government's trying to get to with them, and they can pretty easily be walked around, essentially, we at least leave with the knowledge that fewer agencies are going to use them for more menial purposes, I guess. Anyway, I'm Curtis Miller. That's been the Tie Demon Paid Up podcast, and you've been a great audience for sticking through this entire episode. I can't thank you enough. If you want to subscribe and catch more of this podcast, you can do so on iTunes or on YouTube. And if you want to check out more from myself or Tie Demon, you can check out the YouTube pages. The best place to go for that is just youtube.com/Tie Demon, or you can find just about everything you need on the Tie Demon website, which is just tiedemon.com. You can also find myself and Tie Demon on Twitter at Curtis Miller or at Tie Demon, respectively, where you can feel free to ask me a question or drop us a line. And until the next episode, where we're talking about telecommunications data and how that's going to be stored if this bill passes, thanks for listening, and have a good day to you all.